Welcome to the Hollywood Heretic, the entertainment industry podcast where we break down what's broken and how to fix it. I'm Wade Major, and today I am very, very excited to welcome someone who is both an extraordinary leader in his field as well as someone I am proud to call a friend, Mark Lee. Mark is one of the foremost legal experts on intellectual property and copyright in the world. He is presently a partner at the law firm Ryman, a lecturer at the USC Gould School of Law, and author of Entertainment and Intellectual Property Law, published by Thomson Reuters. He has more than 30 years of experience in the entertainment and high technology industries and has counseled or litigated disputes involving the intellectual property rights of world-famous musicians, authors, actors, photographers, and fictional characters. His courses at USC have covered the entire landscape of intellectual property law, from copyright to trademark and related rights and entertainment law. In short, he is the perfect person to help set the record straight on the boogeyman of the moment, AI. And because I wanted to give us a solid base from which to begin this far-reaching conversation, Mark was kind enough to engage in a dense but illuminating Q&A before this conversation, which is furnished as the text of this post on Substack. So if anyone watching this has not already done so, I would say pause the interview right here, go read the introductory Q&A, and then come back here as we get into the weeds. Because Mark, as I had hoped, your answers to my original questions opened a universe of even more questions. So to start, I'd like to ask you to repeat your very succinct definition of artificial intelligence and how it differs from search engine algorithms and other assistive technologies, because I think that's where most people start to go wrong.
Thank you. Yeah, I'd be happy to do that. Basically, the difference boils down to this. Traditional computer programs, what the computer scientists would call algorithm-based programs, are all ultimately predictable. That is to say, the answer to any question has been worked out in advance. And every time you ask the question, you will get the same answer. In contrast, AI programs exhibit what's called dynamic behavior. They can adapt and evolve as they are trained on more and better data. Answers to questions will differ, often in unpredictable ways. Sometimes they'll improve as the AI learns how to better answer them based on the input it is provided. And the AI decides how to do that. That doesn't mean the answers will always be right. Often they will be horribly wrong. In my field, the law, AI is already famous for giving the wrong answers to legal questions, and often making up non-existent statutes or cases to support the wrong arguments they make. And so some courts have already issued rules that prohibit use of AI in pleadings and motions for that reason. But that's a different issue.
And I was going to ask you about some of those legal particulars, because I find that fascinating. And a longtime friend and colleague of mine, Ray Green, who has done quite a lot of experimenting on AI for production purposes, he sums it up as saying the biggest problem with AI is that it can't hold a thought. And that goes to the point you were just making, that it's a different answer every single time. So let's talk just for a second about the way that I mean, most famously, we've seen the generative AI that gives us all kinds of multiracial American founding fathers and Europeans, where it was kind of garbage in, garbage out. If you teach it to make a mistake, it will make a mistake. Is that the same case in the legal problems, that it's that it hasn't been instructed properly, or is there something deeper in AI that is problematic when you start getting into factual and data-driven areas?
Yeah, and the answer is I can't answer technologically, but my lawyer's perspective is that, number one, AIs don't know truth from error. They are programmed using very sophisticated algorithms and very sophisticated mathematical models to in a way you could say creatively respond to prompts or to questions that people give them. And they come up with the best they can come up with based on that very complicated technology. The answers, are they consistent? No. Do they try to give the same answer every time? Absolutely not. Depending on subtleties in the prompts, its internal algorithms will cause it to come up with different answers that can change unpredictably. And that do create the prospect of almost bizarre and obviously incorrect responses in many settings.
Let's talk for a second then about the creative conundrum that AI has presented. And there's a meme floating around, which I think kind of sums up how most people feel, which is I don't want AI to do poetry and music so I can do the laundry and the dishes. I want it to do the laundry and the dishes so that I can do poetry and music. And I think that's sort of where people come down on it. I'm not opposed to this as a tool, but when it starts to substitute for the creative process, that's where we kind of get into the weeds. What are the challenges right now in terms of, and looking at the agreements just signed last year and the contract negotiations going on right now with animators, where is the dividing line between what creative people are looking to draw on AI as a tool and AI is interfering in the creative and the copyright process? How do we parse that line?
Well, that's from my perspective, you have different players with different interests who want to achieve different results. Obviously, the creative community is, how would I say it? To some might not be threatened to the extent it could be used as a tool to perhaps help, for example, with some sort of orchestral arrangement in music. But they are definitely horrified at the thought that the AI might replace them in creating soundtracks for videos or streaming television or any audiovisual content. From a copyright perspective, though, there isn't really guidance, by which I mean copyright law prohibits certain things and allows many other things. And so to stop something, one can't necessarily do it on a policy basis as a copyright law matter. That is to say, you can't say, well, as a matter of copyright law, I want the AI to do A, B, and C, but I don't want it to do D, E, and F. You can say, well, I don't want it to copy my work, and I don't want it to create new works based on my works without my permission, because that's what copyright law prohibits and what it allows copyright owners to stop other people from doing. So there is ultimately, do you want to make that a matter of legislation? Do you want to make that a matter of regulation? Those are all very difficult and complex questions. And I don't think at this point anybody has a good enough handle on AI, what it can do, what it will do, what people want it to do, to effectively come up with legislation or regulation to deal with that either. So we're left with the crude tools of litigation to try to address the questions that copyright law can address.
So it looks like we're in kind of a Wild West area where, and correct me if I'm wrong on any of this, but the way that, based on what you're saying and the way that I'm reading it, is that we have a technology that is a learning technology that is evolving very rapidly, that is teaching itself very rapidly, moving so quickly that we're playing catch up. So how we have a lot of different ways to try to get in front of it, if we can get in front of it. So I guess the question is, do you think that that between regulation and litigation and legislation, and perhaps eventually having to get a ruling from higher courts, even the Supreme Court, is that process, in labor negotiations as well? So I mean, all of these things happening at the same time. Is is this delaying us being able to get in front of it? I mean, while all of this is happening, AI just keeps rapidly evolving. And it seems to me that eventually, by the time you get a court ruling, it will have evolved to a point where that court ruling no longer really applies to the technology, or where they pass a regulatory, some regulatory guidance or even legislation. But by then, AI has already leapfrogged what was written. I mean, is that a risk that we are legitimately dealing with?
Again, that's to the extent you're asking me technologically, is it a risk? Perhaps, although my hazy understanding is it may not be as much of a risk as people think. And I'm no computer scientist nor engineer, but my understanding is that right now AI can learn from what it is, what it copies, what it consumes. However, it cannot learn from content it creates itself, which would create weird feedback loops if it could. But as a result, AI does not easily, at least at present, technologically, as I understand it, have the ability to learn more than we know and move into areas that beyond our control easily. So we may have some time. I think people, given the obvious potential commercial value and cost savings in many areas, I do think it's very possible and probably likely that there's going to be tremendous disruption throughout the creative communities, because I'm afraid it is likely that AI will soon come to not just supplement, but potentially replace many creative persons' work. Just to give you an analogy, back in the 70s, when the Moog synthesizer was a cutting edge technology, many people would decide they didn't need to hire the orchestra to do their soundtrack anymore, because they could hire one keyboard player who could play it all on the synth.
Right.
And something like that may happen with many kinds of musical works, many kinds of other creative works. In fact, I just read last week where some so-called computer scientist estimates that 90% of all content on the internet, new content on the internet, will be generated by AI in 2025.
Wow.
I'm not sure I buy that. I tend to believe that's somewhat alarmist, but there's no doubt that AI will be used to generate a lot of, for example, the news programming, potentially musical soundtracks, potentially a lot of things, to the extent that they are not prohibited from doing so by the guilds, or potentially by legislation or regulation. But that's farther down the road, in my view.
So talk about the legal landscape right now as you see it. There are a lot of lawsuits. You had made a very interesting distinction between deep fakes and what it does with respect to writing or even visual works. I'd like you to talk a little bit about that and how that, because we have this a previous case in India related to likeness rights. And that's very far reaching. So talk about just for a second about all the lawsuits that are out there and what that means for the difference between these two different, the legalities of these two different things.
Right. Yeah, there are a number. I don't know the exact number, because I keep reading about new ones being filed every week, but I'm sure we may be in the 24 range, perhaps more. There is a few of them have alleged both copyright related claims and what I call the right of publicity. That's the US legal term for name, image, and likeness rights. Different names are given for that law in other countries. But in any event, yes, those two bodies of law are one or both of them are involved in all of these cases. The copyright cases tend to focus on two things. The copyright owning plaintiffs are unhappy because their copyrighted works were copied to teach the AI. And then the AI creates apparently new content based on what it was taught from their works. And so the complaint is, you infringed our copyright when you loaded it into the AI's database, and you infringe our copyright when you create unauthorized derivatives of our works with the new content. Deepfakes are a different issue. There, the AI is given typically a lot of video or a lot of audio, and it will use that to generate apparently audiovisual works, a famous person doing something that they didn't really do. And that could manifest itself in various ways. For example, something I happen to notice, because I represent both parties who were involved, a famous Nirvana song, Smells Like Teen Spirit, is performed apparently by Frank Sinatra on with a big band arrangement on YouTube. And I noticed that because I represented Frank Sinatra Enterprise and Nirvana. And you know what? It's actually a surprisingly good rendition. It shows what a great song Smells Like Teen Spirit really is. Well, I happen to know they didn't get any permission for that. And so in theory, both Frank Sinatra's estate, or Frank Sinatra Enterprises, the company that manages his estate, or Nirvana could complain if they wanted to. Similarly, you could have all manner of things. You could have a romantic comedy with a virtual Brad Pitt and Angelina Jolie that seems to echo portions of their lives without their permission. And you can have the AI write the screenplay, and then you can have the AI generate the content. And then it could use AI to create a soundtrack. And then it could post it and sell advertising. There's some copyright-related claims there, but unrelated to the copyright issues. The person depicted as acting or singing would have a potential claim based on the right of publicity. Now, current right of publicity law is not necessarily what I would call a sharp instrument to attack that. There are certain claims you could make in a few states, but because the right of publicity is generally a matter of state law at present, every state's law is different, and what is legal in some states is illegal in another. And therefore, the ability to successfully stop that with the current right of publicity law is very uncertain.
So let me try to get into what was upsetting the actors and the writers last year, because it sounds like what you're talking about is that one thing was of most concern to the actors and the other thing was of concern to the writers, even though
Correct.
ultimately it's a similar technology. So the animators now are in a panic over this because it looks like a lot of jobs like colorists and in-betweeners, like those jobs could be erased overnight by AI.
Yes. Yes.
So let me give you a scenario that maybe combines all of this. Let's say somebody said, I'm going to use an AI and say, I'd like to know what, Ronald Reagan was once the original choice for Rick in Casablanca. AI, show me Casablanca if it had been made with Ronald Reagan. Or even show me Casablanca if Harrison Ford had been alive at the time, and replace Humphrey Bogart with Harrison Ford and replace Ingrid Bergman with Nicole Kidman. Or show me a colorized version of Casablanca. Now you are doing all of those things. You're taking a copyrighted work and you're playing with likenesses of both deceased and living people. Where does that run afoul or risk running afoul of the law, something like that? Does it have to be monetized? Can you claim a satire? You know, where are all of the little dividing lines that separate all the legal considerations in something like that?
Right. Well, let me just take, those are great questions. Let me just take one of the hypotheticals you gave, because I think that illustrates it pretty well. And that is Ronald Reagan in portraying Rick in Casablanca. Well, there, obviously, the copyright owner, who I suspect is Warner Brothers,
Yeah.
would have a copyright-based claim to the extent that such a video was made. They could reasonably argue that that is an unauthorized derivative work, would be the technical legal term. And I actually think they might have a very good claim for that sort of a use. Could somebody do it and post it on YouTube for free, and would that protect them? No, I don't think it would, because it's still a quasi-commercial use, and you're absolutely creating it. They also would have a claim that there's a direct copyright infringement of Casablanca because they had to copy the original in order to create their version. And I would argue that their version is still an infringing version. And they said, oh, well, what if we did it as a satire? Well, actually, satire is no defense to copyright infringement. Parody can be a defense, but parody is fairly narrowly defined by the Supreme Court to involve a work that makes a critical comment about the original. So it's possible that someone who had Ronald Reagan in Casablanca could argue that they were parodying the original in some way, making some critical comment about the original, but I don't know what that would be. So it's not obvious to me that they could meritoriously assert that, but it would be a claim. So that's the Warner Brothers copyright-related universal claims. But wait a minute, what about Ronald Reagan's estate? Well, he wouldn't own any copyright interest in Casablanca, but his estate would own a right of publicity in his name and likeness under California law. He could argue that they created an unauthorized performance of his work. That would be a difficult claim under current California law because, number one, there is some indication that California law recognizes the right of publicity and performance. But it's also true that historically, the courts have been very sympathetic to First Amendment defenses involving uses of name and likeness in creative works. There have been a number of motion pictures, for example, in which they included images of famous people without permission. The MPAA always argues that's protected speech by the First Amendment, and they don't need to get anybody's permission to do that. They did cave somewhat as a result of the recent guild negotiations, so guild members probably have some protection. And although I haven't studied closely the terms of the most recent agreement, Ronald Reagan being the former president of SAG, I have a feeling that he might get the benefit of that if an MPAA member, at least, created, or if Warner Brothers, let's say Warner Brothers decided to come out with an authorized version of Casablanca with Ronald Reagan, well, the Reagan estate, I suspect, would have some very good claims based on that under guild rules. But if they had to rely on standard right of publicity, if a third party did it without Warner Brothers' permission, it might be more difficult to stop it under current California law, which is, and California has, like many states, has a bill right now that would amend its right of publicity law to stop that, but it hasn't passed, and we don't know if it will. For that matter, the Senate introduced a bill 3 weeks ago called the No Fakes Act that seeks to block that sort of activity. But that's in its earliest stages, and I have no idea if it will be enacted into law. So at present, there's a lot of uncertainty.
Boy. So let me throw you another scenario, and if you could comment on this one too. Let's say, because I know there are a lot of people who are they're using AI to analyze legislation. They'll scan a piece of legislation in, and they'll ask AI to analyze it and to create a pro argument or a con argument, and it helps them sort of get ahead of the game on a very, very short campaign and legislative calendar. Sounds a little sketchy to me, but let's say somebody does that creatively. Let's say someone says, I'd like to do a movie that is a mashup of a comedic mashup of Terminator and Tootsie, with a little bit of Back to the Future in it. So let's say they scan all three of those screenplays in, and they have an AI generate a variety of takes on mashing up those three screenplays. From what I've heard you say, it sounds like that resulting screenplay cannot be copyrighted as an independent work, and that all three of those other copyright claimants, the other authors and the copyright holders of the other three screenplays, would have a claim on what results. But how would you prove it if that person did not reveal that that's what they had done?
The answer is everything would depend on what ultimately came out. That is to say, how much of what the AI produced was recognizable from the three underlying works you described. The copyright owners of the three films very well might have claims, but they would have to prove what everyone who alleges copyright infringement has to prove, which is that the defendant took and used without permission protectable elements from their underlying works. And so, for example, if they had actual scenes or if they had characters from the films that were original to the films, well, yeah, you might have something. If you literally had Tootsie and the Terminator in a scene together, and they're recognizably Tootsie and the Terminator, then you know what? You'd probably have a copyright infringement thing, because the characters are often protectable elements in such underlying works. Similarly, if they actually had Arnold Schwarzenegger playing the Terminator in the film, Arnold Schwarzenegger would have a claim because they've shown him performing in this motion picture without his permission. And they've imitated a performance of his in the work. And so that would be a non-copyright related claim that could be asserted.
What if you do that and then you start changing things just enough? So let's say you've thrown a mashup of screenplays in there, it spits something out, and that's now the basis for what you're going to do moving forward. And let's say you use that as a basis, but you change 65, 70% of it, you change the character names, it's sort of gotten you off on a footing. Can someone argue that, well, look, it just gave me the idea. I just wanted to generate something. I saw what it was. And then I went back, and because it sort of inspired me, I changed 85% of it. How does that differ, or does it differ from someone who just personally reads those three screenplays, gets a bunch of ideas, and they use that as inspiration to write something? How do we parse that?
Yeah. And the answer, I can answer that question in 2 words, and those 2 words are, it depends. The devil or the angels are in the details. The truth is, ideas are not protectable by copyright law. And people are free to take ideas from other works and to use them in new works. In fact, I dare say most creators do that. Many classic rock musicians have admitted they listened to the Beatles, and that was instrumental in how they came up with their works. Does that mean they infringed the Beatles songbook? No. They took ideas and they then created new works. In the hypo you described, it would depend very much on how much was changed and how much was taken. To the extent they took substantially similar protectable elements from the underlying work, either individually or in combination, they might be held liable for copyright infringement. To the extent everything they took is not protectable, that is, they're just ideas that they then reinvented to create something new, then they might not be liable for copyright infringement. And that is something similar to that will probably play out in many of the AI cases, because many of these creators are unhappy because what the AI creates, which you correctly noted before, is not protectable. AI created work is not protectable as a matter of US copyright law. So, and if you have an AI create something, unless you have introduced your own new independently protectable original elements into the work, the AI work will not be protectable. What you create, whatever you introduce will be, but what the AI creates isn't. But it could still infringe. And many people who might just say, I don't care about getting a copyright in my work. I just want to have a website with a lot of fun content that people will want to watch, and I'll charge advertisers to put their products on it, and I'll make my money through advertising. So I can easily see someone trying that as a business model online. And if the work, from a copyright perspective, if what they took isn't independently protectable, isn't perceptible, isn't substantially similar, they might be able to do that. If it is substantially similar, if it does include protectable elements from underlying works that you can identify, then they might be liable for copyright infringement. To the extent they use an actor or a performer's image without permission and show them rendering a performance they didn't actually render, I think the artist would have a claim or should have a claim, although it's very unclear right now. I would caution anyone who is thinking about pursuing such a claim to really consult with their counsel and make sure they file it in the best possible jurisdiction, because it could very easily go wrong.
So, Tom, you had mentioned the Google case with respect to fair use, and fair use seems to be a claim that is coming up a lot here. How do you see fair use as a component in this?
Well, it is absolutely a very big issue, because in the AI setting, AIs consume incredible amounts of data, or as how a software guy would say it, from a lawyer's perspective, they copy a lot, millions of copyrighted works. So there's copying. They've got a claim to avoid liability then. They've got to say, oh, but we did it for a reason it shouldn't be infringing. And there have been some decisions in the past 10 or 15 years that have been mildly surprising to me. The Google case I mentioned, in fact, there are a couple of Google cases, but in one, Google launched what it called Project Gutenberg, in which it publicly announced with pride that their goal was to copy every book ever written in the English language. Well, a lot of them are old, they're out of copyright now, but you know what? A lot of them are within copyright. And so they were sued by groups of authors, or by the Authors Guild in one case, complaining that they're copying all our stuff. And that was held fair use because that court held, well, yes, they're copying it, but they're not making it publicly available. They're only allowing the public to see little snippets of it. And they're also making it available on a nonprofit basis to libraries, so libraries can digitally scan it. And so that was held to be fair use. That case did not go to the Supreme Court. Well, AI does something similar, and it doesn't produce the entire underlying works. So the argument will go, Therefore, that copy should be fair use, just like it was in the Google case. Will that work? I don't know. But it is absolutely being raised. It's been raised in a case in one in Northern California, and is an issue involving fair use of AI-generated works is going to trial next week in Delaware, of all cases, of all places. And that's a case involving my publisher, Thomson Reuters, which is also creates Westlaw, which is something that lawyers are all familiar with. It's a big online legal research tool. Somebody else came in and copied, well, not just the cases, and you may not know, Wade, but cases are not copyrightable. They're written by judges sitting on the bench. And so what the judge writes is public domain for everyone. And anybody is free to copy it. But West also has these great headnotes and what it calls the West system, in which it has over a century or more has very carefully organized and arranged the cases that it has published. And so you can look it up by topic and find all the cases that deal with the topic. Well, what happened in that case was a competitor came in and copied all the West headnotes and the West system. And they want to then use that to create a competitive online electronic legal search database. And so Thomson Reuters, which owns West and Westlaw, got unhappy, sued them for copyright infringement. And that case is going to trial next week. The defense by the defendant, Ross Intelligence, oh, it's fair use. And that case will be interesting because as opposed to, a movie or a song or a novel, the West legal system really includes a lot of non-protectable material. That is, all those actual decisions. And when it comes to summarizing a case, it's not, there aren't that many ways you can summarize it, I think. So it will be, which tends to apparently make stronger the fair use defense that Ross Intelligence is asserting. And a jury may decide this next week. We'll find out. And I'll be very interested to see what the jury says. The judge in the case decided it could not rule on it as a matter of law, so it denied a motion for summary judgment before trial. But a jury is going to decide it now.
I want to talk for a second about rogue states, because that's always kind of another factor here. And years ago, when I had the piracy beat at Box Office Magazine, I wrote the sort of the annual update on piracy. And I talked to the US Trade Rep and the MPAA, and it was always kind of a two-piece puzzle, which was, well, yes, we have these rogue states. They are offenders to a variety of degrees: China, Malaysia, India, Pakistan, Russia. At the time, there were some Eastern European countries just coming out of communism where the rule of law wasn't quite as shored up as it is today. And the question was, well, we need to first get them to implement the laws, and then we need to get enforcement. And getting these countries to pass the right laws, not necessarily a problem. Getting them to enforce their laws, much, much bigger challenge. And it seems to me like we're in that place again here. Is that a fair assessment? And are there other challenges where rogue states may be concerned?
Yes. And I completely concur with that assessment. The truth is, most rogue states are signatories to comprehensive multinational treaties protecting copyright law. And also trademark law. Not so much on the right of publicity as the name, image, and likeness rights, and some other things. But they're being signatories notwithstanding, and they're potentially even having laws on their books that appear to comply with the minimum standards established by the multinational treaties. They nevertheless do not aggressively enforce their rights domestically. And that has been true before, and it's true now. And I actually fully expect that as the cost of AI technology and creating works goes down, there will be a host of new potential infringers. They won't be traditional pirates in the sense that they won't be knocking off somebody else's movie on DVD or even streaming it from another country, because it is possible to use technology to kind of block streaming technology in certain circumstances. But they very well may use AI to create all manner of, quote, new works that US content creators and artists might believe infringe their rights, but which will be very difficult to stop traditionally. And even with old tech piracy, it's hard, I will say. There is right now actually some creative judicial efforts to stop countries from pirate states by using U.S. litigation, for example. This is
Right.
There's been nothing like that in AI that I know of, but I could see that being used in the AI space as well, to the extent U.S. laws would stop it.
So we are really in uncharted territory. It sounds like it's going to take a lot of years to shake this out as different countries and different states and try to sort out their laws, and the technology eventually matures. In the meantime, we've obviously got creatives who have their guilds and their unions looking out for them. And I know AI is a whole different thing for the Teamsters. They're concerned with autonomous vehicles, and that's a completely separate conversation. But in the meantime, you've obviously got all the guilds and the unions looking out for their contract protection. But if you're just an average everyday workaday writer or an animator or a composer or songwriter, what can you do, if anything, to protect yourself just as an individual creator? Do you have any thoughts as to what they can do before they sit down and write that screenplay or put together that piece of music?
Yeah, unfortunately, no. There's something you could do that would absolutely protect it, and that is don't ever make it available digitally online. That might do it, but then that defeats the purpose of the creative effort. If nobody can see it, why are you creating it? But unfortunately, there is no magic bullet solution for your typical screenwriter, songwriter, composer, novelist. There's just no easy solution, I'm sorry to say. You create a work, you can register it for copyright, should do that. You can try to join a guild that will do its best to protect your interests in this rapidly changing marketplace. But you've got to recognize none of that will be enough. It won't prevent your work from being copied, and it won't give you bulletproof protection in the future, I'm sorry to say. It really is going to be a strange or brave new world.
Well, on that point, I think that's a good place to end. I just ask you a last question. Are you optimistic that any of this will resolve, or are we going to be fighting these battles for the foreseeable future?
Legally, I'm sure there are going to be battles going forward. I speculate, because this has happened with all revolutionary technology to this point, it will shake out in some way that I don't pretend to be able to predict right now, in a way that hopefully the industry can live with. To take the music example, where I mentioned how the synthesizer eroded the capacity of many musicians to get work. But that did eventually shake out in a way that was acceptable, I hope, for members of the musicians union. I suspect things will resolve in the next 5 to 10 years to a considerable degree. There may or may not still be ongoing problems depending on what ultimate resolutions are reached in the courts and in the legislatures. But ultimately, it probably will go forward. And I'm optimistic there will still be a vibrant creative community to help enrich our lives.
Well, that is encouraging. So thank you for all of that expertise, Mark. It's been invaluable. I want to thank my guest, Mark Lee of Ryman and the USC Gould School of Law, as well as author of Entertainment and Intellectual Property Law, which you are regularly updating, I understand, right? That
Yes,
gets an
in
update
fact,
every so often.
yes, I am. I'm writing a chapter on artificial intelligence right now.
All right. And where would they find that?
It's available online, Thomson Reuters. So you go online and look up entertainment and intellectual property law, you can find it in minutes.
All right. Excellent. Thank you, Mark. And anyone viewing this podcast who has not yet subscribed to The Hollywood Heretic, please do so by visiting hollywoodheretic.substack.com and consider becoming a paid subscriber for access to members-only content and podcast episodes. Until next time, please go out and make movies matter.